I thank the honourable member for Wilson. I call the honourable member for Fisher.
Thank you, Mr Deputy Speaker. The security of the nation is the primary responsibility of any federal government. The Parliamentary Joint Committee on Intelligence and Security is widely recognised as the most important and functional committee of the Parliament and has played a key role in supporting successive federal governments to protect the national security of Australia. Its members, past and present, have prided themselves on working together constructively in a bipartisan way in the national interest. At the outset, the opposition affirms all of the 10 recommendations contained within the comprehensive review, which are the subject of this inquiry. The opposition agrees with those recommendations, as it does with the changes sought by the government in respect to amending Part 2 of the Intelligence Services Act, that is in relation to clarifying the current uncertainty relating to the level of detail required in a ministerial direction issued under Section 6(1)(a) of the Intelligence Services Act. Mr Deputy Speaker, the sole point of contention between the government and opposition members of the committee arises out of the government's unilateral proposal to change the member composition and quorum requirements of the committee. Mr Deputy Speaker, it is with considerable regret that the opposition feels compelled to provide a dissenting report in this inquiry. Opposition members note that this is the first time in 17 years that the committee has not reached a consensus on its recommendations, and it is the first time that I have risen in this place to speak on a report the subject of the inquiry. And I've done that. I've always tried to, on behalf of opposition members, to allow the Australian public to consider that when this committee speaks, it speaks with the voice of both the government and the opposition. But on this occasion I have to rise. Now, Mr Deputy Speaker, the committee is peculiar in nature from all other committees of the Parliament in that it receives classified briefings from security agencies. Classified information is shared with members of the committee up to the most classified level, namely top secret. Just like relevant ministers who operate in this sphere, members of the committee are not required to possess any security clearances whatsoever. Now, in relation to the proposed amendments, Schedule 1, Part 3 of the bill would amend the Intelligence Services Act to provide that the committee is to consist of 13 members, comprised of at least 2 government senators, 2 government members of the House of Representatives, 2 non-government senators and 2 non-government members of the House of Representatives. The remaining 5 members could be drawn from either chamber. It also raises the quorum requirements from 6 to 7. Now, one of the great concerns I have in relation to this inquiry is the manner in which it has been conducted by the government. Now, this inquiry has been irregular, it has been rushed, and it has been contrary to the good conduct of national security inquiry of this importance. On the 29th of March 2023, the Attorney-General referred the bill to the Committee for Inquiry and Report. The committee was asked to report less than 1 month later. No justification was provided for this extremely short timeframe. This unreasonably short timeline for the inquiry meant stakeholders were given just 5 business days to provide submissions. Such a short timeframe is disrespectful to stakeholders and otherwise unacceptable when it involves the examination of important amendments to national security legislation. Such inordinate pressure regarding legislation which is not so time-sensitive is inexcusable and is most certainly contrary to the Set the Standard report on the independent review into the Commonwealth parliamentary workplaces. It has to be remembered that these timeframes impact not just on members in this place, but importantly on the Secretariat that supports us members, as of course it does to stakeholders. Stakeholders and the committee's work is hindered by the undue haste in which this inquiry has been conducted. In fact, the Law Council, in their submissions, said The Law Council has been unable to consider all aspects of the bill in detail because of the limited time for consultation, nor has it had the opportunity to adequately consult with its membership on the proposed reforms. Similar complaints were made in other submissions and correspondence received by the committee. In its written submission, Attorney-General's Department claimed that the amendment to Section 28, subsection 2 of the Intelligence Services Act is intended to allow for greater flexibility in determining PJCIS membership, while retaining the requirement for representation of both the Senate and the House of Representatives and government and non-government members. Now, Mr Deputy Speaker, none of the other written submissions included any reference to the changes to the composition of this committee. In oral evidence given on the 11th of April, when asked about the risks involved in increasing the number of people on the committee and the risk of classified information being leaked, the Director-General of Security said, "Need to know is a sound principle, and yes, the more people know something, the risk increases." In response to a question on notice, the Attorney-General's Department conceded that it did not consult with or advise any non-government parliamentarians on the proposed changes to the membership and composition of the committee. It also conceded that these measures were a recommendation of the government. No appropriate justification has been provided to the committee by the Attorney-General as to the compression of relevant timeframes in the conduct of this inquiry. The committee relies heavily upon well-researched, considered, meaningful submissions made by stakeholders in order to do its important work. If the committee is to properly perform its statutory role of oversight of intelligence agencies and relevant legislation, it must be afforded appropriate timeframes in which to conduct its work, unless exceptional circumstances apply, and that is not the case here. The government has tacked on these proposed reforms to a bill, the contents of which are not time-sensitive. The former and current governments have been working their way through the comprehensive review's 203 recommendations since December 2019. There's no evidence that supports the assertion by the Attorney-General's Department that the proposed changes to the composition of the committee would lead to greater oversight and accountability of Australia's intelligence and security agencies. Simply by adding a further 2 members of the committee would not lead to any greater parliamentary oversight. Indeed, the opposite may be the case. To allow more members on the committee could result in a perverse outcome. By sharing the responsibility between more members, this could result in a reduction in the knowledge base of individual members. In addition, it's important to note that the proposed amendments to Section 28, subsection 2 of the Intelligence Services Act could result in the government enjoying an overwhelming majority of 9 positions on the committee, with the non-government members being limited to just 4 positions. And it is entirely possible, under the strict wording of the legislation, that the opposition could be cut out altogether, and those 4 non-government positions could be handed to the crossbench. This is unacceptable to the opposition. Such an outcome would not only significantly weaken the utility of the committee's oversight responsibilities, but it would almost certainly impact upon the bipartisan nature and good standing of this committee. It could also create a corporate knowledge gap for relevant members of the opposition who may be called to serve on the committee after a change of government. Politics goes in cycles, and those opposite should always remember that. Now, the opposition accepts the government of the day should retain a majority on the committee, as currently required by Section 28, subsection 3. We have no quibble with that. The opposition considers that the only members who should sit on the committee should be parties of government. That has been the case throughout since this committee was established in 1988, with one exception. That is by convention. Yes, the legislation enables effectively the Prime Minister of the day to appoint crossbenchers, but by convention that has not been the case, with only one exception. The addition of 2 more members to the committee does increase the risk of classified material being leaked, either intentionally or inadvertently, as the Director-General of Security stated in his oral evidence. Axiomatically, the less people who know a secret, the less chance that secret has of falling into the wrong hands. The opposition is greatly concerned that the government's decision to increase the number of members of the committee is as a result of some deal done between the government and the crossbench, and the Prime Minister intends to appoint at least one member of the crossbench as one of the two additional members of the committee. The success of the committee over the years is in part as a result of it being comprised of members of the parties of government, which have a stake in ensuring that national security legislation is effective, workable, consistent and appropriate to the risks faced, no matter what party is in government. This is important because, with only one exception, as I've said, at all times, members being on this committee have been members of parties of government. The addition of a member of the crossbench risks undermining the trust and confidence built up on the committee over successive parliaments and render it simply like any other committee of the parliament. Given the history of the bipartisanship on the committee, if the government believed these changes were necessary and urgent, they could have approached this inquiry very differently, including by consulting with and seeking the support of the opposition. Instead, by unilaterally proposing changes to the committee as part of a rushed inquiry, the government has given the impression that a political deal has been done with the crossbench to fundamentally alter the composition and therefore the culture of this committee. The proof will be in the pudding as to what happens over the next couple of months. The opposition also opposes the proposed changes to the committee composition, which could see a significant underrepresentation of one chamber or the other. The opposition is concerned that the proposed changes to the composition of the committee is a result of internal politics within the government. Membership on the committee is a sought-after prize for many members of parliament. After the May 22 election, the government was not able to resolve who its members of the committee would be for at least 3 months. Despite the committee being widely recognised as the most important committee of the parliament, it had not been capable of being reconvened until the 6th of September 2022. The committee's important work should never be held hostage by any party's internal machinations. The proposed amendments to Section 28, subsection 2 of the Intelligence Services Act were not recommended by Mr Richardson in the comprehensive review. If these amendments were considered necessary or appropriate, one wonders why they were not included in the most detailed examination of the intelligence and security framework since the Hope Royal Commission of the 70s and 80s. Indeed, on the evidence of the Attorney-General's Department, the proposed amendments to the composition of the committee were not recommended by any stakeholder. The proposed changes to Section 28, subsection 2 of the Intelligence Services Act emanate from the government itself, entirely devoid of any consultation with the parliament or stakeholders outside of the executive. The opposition has not sought to block the proposed amendments to Section 28, subsection 2 of the Intelligence Services Act for opposition's sake. Rather, it has always sought to be constructive in its approach to the reform of important national security legislation, which is why the opposition provided various alternatives for the government to consider other than the one it landed on. And the fact that the government handed down its response to this recommendation on the same day that the report was provided suggests that the government's response was well and truly they'd made their mind up. This government knew where they were going. It was the same day the report was handed down, the government provided its response. This was a fait accompli, decided, determined, lock, stock and barrel by the Attorney-General before this matter even went to the committee. It is a disgrace, and I use those terms very carefully. because it is with no joy that I rise in this place. The first time in 17 years that the PJCIS has not handed down a bipartisan report. Thank you.
I thank the honourable member for Fisher, and I call the honourable